7:35, so I'm going to kick this off. Today we're going to talk about Syndication Legalese Demystified. We have here Mauricio Rauld. He is the founder, CEO, and securities attorney in the Premier Law Group. And he's here to talk about what the syndication documents are all about and how you can, what you need to pay attention to in these syndication documents. Because I know as a passive investor, when I started on a syndication, I really didn't understand what these documents were all about. And when someone sent me a DocuSign, I just went click, click, click and signed them. So that's, I think, what a lot of us do. And I know there are a few people, I know some friends who actually read every word of it, and kudos to them. And I'm just not a legalese person. So I thought this would be really useful for our viewers today to listen to understand when you get a syndication document, what does each document mean? And what's the fine print you should be paying attention to? And so Mauricio today is going to talk to us about this. I'm Kavitha Baratakke. A lot of you guys know me already. A quick disclaimer, of course, we have an attorney here talking about stuff he's very qualified to talk, so less of a disclaimer today, but always consult your own attorney when you're doing any docs, any specific docs that you're going through for a syndication. We're not presenting any offer here, or we're not soliciting any investment here. We're just going to talk through what the docs are and how you can be a better investor and understand these documents better. Some quick housekeeping before we get started. Everyone's obviously on mute. This is a webinar, so you can't talk unless I unmute you. Happy to do that if you have something to ask. Generally, our Q&A is through a Q&A box and not the chat box. So please locate the Q&A box in your Zoom application. It will say Q&A on it with the little, a briefcase with a little Q on it, or a circle. I don't know what that is. Please use that to ask questions, because it keeps me on track and it helps me kind of answer them and then dismiss them as I answer it. If you answer questions in the chat box and some people in the Q&A box, it really becomes hard to track. A lot of people ask me this after the webinar is done and they want to see the recording again. So yes, this webinar will be recorded, and it is being recorded right now, and the link will be sent to all the registered attendees within 24 hours. I see a lot of people, it goes to their spam folder. So they ask me over and over again. I end up having to deal with a lot of email post webinars. So please check and whitelist my email so it doesn't go to your spam folder. A lot of folks are familiar with me, but some new faces today on. So a quick overview of who I am. I'm a accredited real estate investor. I've been investing in single family and multifamily real estate for over 10 years. I was full-time in technology in IBM, and then a company called Atlassian. And recently, last June, moved over full-time to real estate as a syndicator. I have a master's in computer science from Texas A&M. And I manage and own rentals still in Austin and San Antonio, and also have invested as a multifamily limited partner in quite a few doors and general partner in some more. I have a 15-year-old daughter, and we live in Austin with my 2 little puppies and my daughter. Our guest speaker today, Mauricio, is very well known in the syndication circle. He is an educator at heart, and I actually had the pleasure of always watched him and watched a lot of the content that he puts out. He adds a lot of value to all of us in the syndication business. And he speaks a lot about how we can be compliant with the federal and state security laws. And he always says this, and I think it's funny, he keeps syndicators out of jail. It's funny, but it's true. He has over 20 years of security experience and is one of the premier syndication attorneys in the country today. He's recognized also as a top California attorneys under 40 by Super Lawyers magazine. So he has a lot of followers, a lot of people that he's working with, a lot of syndicators. So I'm really excited to have him on. He is a graduate of the University of California at Berkeley. And he lives in Southern California with his wife, Heidi, and 2 little girls, Adelina and Alessandra. With that, I'm going to hand it over to Mauricio to introduce himself and also talk through our topic today. Thank you so much for being on, Mauricio.
No, thanks so much for having me, Kavitha. Really appreciate it. Really appreciate everybody being on today. I'm seeing quite a few. It always surprises me and amazes me when I speak and there's quite a few people on, because at the end of the day, I'm a lawyer, and I always feel interesting that people want to come see lawyers speak. So I'm actually very humbled and honored that you guys would take time out of your evening and spend some time with us today. And I'm excited about today because usually I'm usually talking about things where it relates to the syndicator themselves. That's that's who I represent. I represent syndicators or sponsors of syndications, and I help them put together these documents, and I make sure that they raise the money legally, and as you mentioned, make sure they stay out of jail. I don't usually talk too much about the flip side, which is, from a passive investors and what you should be looking at in terms of documentation and structures and things. So this will be a little bit new, or something not new, but different, that I don't usually put out too much content on. So I'm looking forward to this. And I think, we talked about a few things that we wanted to cover. And I think the first thing you wanted me to cover was sort of what's the typical documentations that you would expect to see in a syndication. And so let's do this organized. I like the way you organize this talk. And so let's just go through these docs. These are what I call the offering documents. Just to kind of pull back just a little bit, just to give a little bit of background. Anytime you're raising money, you're issuing securities. It's why the SEC is involved. That's why the securities commissions are involved. And one of the requirements, almost, I'm going to say in our world, probably 99% of the time, if not 100% of the time, you are required to provide, certain disclosures to your passive investors prior to them writing you a check. And so these are the common documents of these offering documents. Put those in quotations. And we're going to go through them one by one. But the main one, the big one really, is this PPM that you've heard of before, the Private Placement Memorandum. And this is the document that essentially tells your investors a couple things. One, it tells the investors all the ways that your deal or the sponsor's deal can go wrong. It's actually, if you've never seen a PPM before and you're a passive investor and you're about to write a check, it's not uncommon to get a little bit concerned, because you're just basically listing all the ways you could lose all your money. It's not a fun document to read. And I also always counsel my clients to maybe even, prepare the investors for that and just let them know, look, the PPM's coming. It's a legal doc. It's required by law in most cases. And but this is where you just put down every single thing that you think the investor should know, prior to making an investment. The investor is required to have all this information so they can make an intelligent decision. So all the ways your deal can go wrong. And also if you've got something in your, skeletons in your closet, some disclosures that you may need to make, maybe the sponsor had some legal issues, some financial issues, filed for bankruptcy or, what have you, had some lawsuits. That's things that you typically have to disclose, because that is something that the investor is obviously going to want to know. And so at the end of the day, if you have to ask, should I put that in there? That the answer is probably yes, because if you thought about it, it's probably relevant to the investor. One of my favorite analogies, and I make this a lot, and I don't know how many of you have heard this before, but I always analogize the PPM with the medical consent forms that you get when you go into surgery. I personally have horrendous teeth, and I've had oral surgery, I think 3 times now. And I've had surgeries quite a few times. And every time you go have a surgery, whether it's minor or major, they give you typically it's a yellow sheet, a medical consent form, and it just says, look, you're going in for surgery, and here's all the things that could potentially go wrong or side effects from your surgery. You can have some bleeding, some infections, you could die, and I always get that one with my, when I get my wisdom teeth pulled, one of the things that gets disclosed, I could die. And even though you don't expect it, that's what you see in the medical consent form, and then you sign off on that, just acknowledging, hey, I understand these risks, and I go ahead and do the surgery anyway. That's what the PPM is. It's just a disclosure document that lists all the ways your deal can go wrong. One of the things to recognize, and I may allude to this a little bit later on, but this is a good place now that I'm talking about it that it makes sense. If you are a non-accredited investor, meaning an investor who does not have $1 million in net worth, excluding your primary residence, or you earned less than $200,000 a year, or have earned $200,000 a year for the last 2 years, and don't expect to make that this year, then a PPM is legally required. the level of disclosures that the sponsor must give the passive investors that are non-accredited is the same level of disclosures you give when you essentially register or mini register a syndication. So that's why this PPM is super detailed, super complete. Now, if all of the investors happen to be accredited, then the PPM is actually technically optional because you actually get to decide what type of disclosures you're going to give your accredited investors. Now, you still have to give them disclosures because, you know, inevitably you're going to be saying something about your deal. So you're going to have a business plan, you're going to say something at a presentation. And so those representations need to be complete. And so you have some kind of a variation of a PPM that's probably more closer or more akin to a disclosure document if you go that route. My recommendation to my clients is to do a PPM no matter what, because the PPM, in my view, is a double-edged sword / shield, which is it protects the investors because you're disclosing everything, but it also protects the syndicator because obviously if something goes wrong and you've disclosed it, then you can always point to your document and say, yes, you know, I disclosed to you that there was a potential risk that we, for example, could have another 2008 crisis and we may not be able to refinance or execute our business plan. So anyway, probably beating that one to death, but that's the PPM. That's the private placement memorandum, which is the main one. The second document you'll see, which is typically an exhibit, typically, at least the way I do them, is you'll have a private placement memorandum, and then the following documents will all be exhibits to this PPM. And the next one is the operating agreement. You've all heard of an operating agreement. Hopefully, an operating agreement are basically the rules and regulations of any LLC, a limited liability company. Most indicators will use an LLC as a structure. I'm going to venture to say 90 to 95% of people use an LLC. Some people still use a limited partnership, an LP. Back in the day, you know, 20, 30, 40 years ago, LPs were much more prominent because number one, well, back in the day, LLCs didn't exist, but there are also some tax benefits for having LPs. And so if you talk to older syndicators, you may see an LP structure, but generally these days, LLCs is the most favored entity, and an operating agreement is the rules and regulations. Basically, any time you have a dispute or you're trying to figure out, for example, I got an email today from a client that was like, well, you know, just remind me, Mauricio, you know, how are funds going to be distributed, for example? Once we close on the property, when do funds begin? You know, what's the process for distributing those funds? That's going to be contained in the operating agreement. And if you ever have a dispute and you either not sure about something or you want to, you know, maybe get rid of the sponsor or just do something, you always first have to go to that operating agreement because that's going to list every single rule and procedure in there. One of the things that's really important is to understand that operating agreement actually supersedes the PPM from an operational standpoint, meaning if there's a conflict, I've seen this a lot, where the PPM will say one thing, but the operating agreement may even just not have it in there. You know, for example, this is kind of an extreme, and it's usually not intentional, it's just either poorly drafted or there's a communication breakdown, but your PPM could say you're going to get an 8% preferred, and that's the idea. You're going to get an 8% preferred, and then, you know, then we're going to split everything 80-20, but that has to be in the operating agreement. If it's not in the operating agreement, then it's not going to happen. So it's just very important to make sure that you're reviewing the operating agreement, not only to understand what the processes and procedures are, but also to make sure it matches the PPM. That's probably one key thing. Voting, obviously anything to do with voting and distributions and you know, getting rid of managers, or if you want to sell your interest, like all those questions that you have, the answer is always in the operating agreement. And in fact, no matter what somebody tells you the answer is always whatever is in the operating agreement. So you'll typically hear lawyers, or you should be hearing lawyers, when somebody asks a question, the first thing is, well, let's check the operating agreement because that's what's going to govern all of these questions. So that's kind of the operating agreement that's in place. The subscription agreement, and some people do a little bit different. I separate my subscription agreement from the next document, but the subscription agreement is just basically it's actually the legal document that actually commits the passive investor to invest. So that's the document where somewhere in that document, you're going to write down how much money you're going to invest, how many shares, or in this case, membership units of the company you're going to own in exchange for that investment. It's going to have your information, your name, your address, your legal name, if it's an entity, the LLC, you being the manager, all your EIN, all those kind of technical information is in the subscription agreement. And that's really the document that commits you. Typically, the investment officially happens when both parties execute that subscription agreement. So typically the investor signs, and then the sponsor will also countersign that subscription agreement. And typically that's what creates that legally binding contract, that thing. I'm having trouble opening the something or other. I couldn't see that. Anyway, oh, the Q&A, sorry, the Q&A. So that's the subscription agreement. And then on the next slide, you'll see the investor questionnaire. And again, some people combine the subscription agreement and the investor questionnaire into one document, and that's fine. But there's always is there something going on, technical difficulty?
Oh,
No?
we're okay. We're okay. You can keep going. Sorry.
Right. No
I'm
worries.
having trouble opening the Q&A today. I don't know why, but so please type your questions in the chat box. Sorry.
That whole spiel. The investor questionnaire is really important, mostly important for the sponsor. I wouldn't say it's as important for the passive, but the sponsor, depending on an exemption that they're relying on, may be limited to the amount of non-accredited investors that they accept. And so this is a way that they can document whether you as a passive investor are accredited or non-accredited, and then you can keep track of how many non-accrediteds are in the deal. And also the questionnaire is also a place where you can ask questions about the level of sophistication of the investor, because that's also an important metric. The syndicator clearly, does not want to be taking, your last dollar, or shouldn't be taking your last dollar. So if you've got, $100,000 in investable cash, you don't want to be putting all of it into one deal. So these are all kind of questions that we ask, so that the sponsor can ascertain what type of investor that we have, and whether they're accredited, non-accredited, and their level of sophistication. So that's the questionnaire. And then the business plan, which sometimes I could even argue is at the beginning, but the business plan is the document that the sponsor puts together. It's a marketing document in the sense that this is where, honestly, what most people read. I'll be honest, we were talking about offline before we got on here, that most people, I don't think of these days, I say most people, yeah, most people, I think that's right. Most people, I think, don't read the PPM operating agreement, which they should. But they don't. They're going to make their decision usually from the business plan. That's where you have all the financials and what are they going to do with your money, all the pretty pictures, all the information about the marketplace, all the information about the sponsors. Like, you can literally make that high level decision based on the business plan, and then also with some follow-up conversation with the sponsor, which is something that I think you absolutely should do. Once you review the business plan and you're interested in investing, you should definitely pick up the phone and have a conversation with the sponsor and ask questions and make sure that you're clear on what you're getting into, because you as a passive investor don't want to be investing in something you don't want. And honestly, the sponsor also doesn't want to have an investor in there that it's not right for. So if there's some misunderstanding or something, it's better to figure that out beforehand, before going in there. So that's kind of the documentation in general. Now, sometimes you'll have some additional documents, the most common being probably a note. If there's some kind of a promissory note or a loan component to the syndication, you may see a promissory note or a convertible note, as the last exhibit. And then again, each deal is unique and may have some additional documents that aren't traditionally there. But certainly these are the ones that you should definitely expect to see. And if you don't see these documents, that's kind of a red flag. And I think I might be getting ahead of myself, so I'll stop. I'll just tease it with that. But if you don't see a PPM and you're a non-accredited investor, something's going on there, and I would encourage people to ask a little bit more questions. So that's kind of the documentation. The next thing in terms of okay, now you've got the documentation here. I obviously recommend everybody read it. Look, everybody really should read every single line of those documents. Now, they're long. They're 120, 150 pages long. They're very boring. They cure insomnia, as I like to joke, but it's really important to read. But the things that I think there's some things that you want to pay specific attention to. One of them, I think one of the most critical things just in general, but also that this information will be in the business plan, is the qualification or the background of the sponsor. That's, in my opinion, this is not a legal thing, but in my opinion, that's probably one of the most, or if not the most important thing I think a passive investor should be looking at are the credentials of the sponsor. There's one thing to put it all on a pretty piece of paper and put pretty pictures and come up with a spreadsheet, and this is how everything, put it all as a plan. There's a completely different thing to actually execute on that plan and deliver the results. And that comes from the sponsor's experience and background, and their ability to execute. So I think that's probably the most important thing I would look at, even more so than the property itself. I mean, obviously all these other things are important in the market, but if you don't have a good sponsor, I don't care how great the market and how great the property is, I think you're just adding to your risk. So anyway, so that's kind of thing on the sponsor. The other thing that I think you really need to look at is just matching your risk tolerance with the risk tolerance of the sponsor and the risk tolerance that's in the documentation. What do I mean by that? Well, let's just say you're, kind of the classic example. Let's say you're later on in your life and you're 70 years old or 80 years old and you're looking for cash flow, and this happens to be, a development deal that's going to have no cash flow at the beginning and very little cash flow at the beginning of the project, and it all happens at the back end. That's not a good fit for you and the sponsor. So, same thing with, one of the things I'm seeing a lot, at least on my personal side, is if you think that, we're kind of thinning out on, where we are in the market cycle, and, there's potentially a recession coming or a slowdown coming in the next few years, then having a deal that has short-term debt on it, a bridge loan, a 12-month loan on it with the hope to refinance later, that's not going to jive with your risk tolerance. There's plenty of sponsors that do really short-term loans with the idea that they'll refinance in 12 to 18 months. And then I've got other sponsors that go out, 10 years just to kind of mitigate that risk. So just understanding what your risk tolerance is and making sure it matches with the investors, because there is something that's called a risk-adjusted return. And just because the returns are a certain number, that's one thing, but you really want to make sure it's risk-adjusted and just making sure it matches your tolerance. What's the other one? Oh my God. So the other one you really want to pay, a lot of people go straight to the financials, which makes sense. You really want to look, when you're looking at a pro forma or the underwriting, or however you want to call it, just make sure you understand what the assumptions are in preparing the pro forma. For probably the easiest one that I can come up with is, there's 1,000 assumptions that a sponsor is going to make in putting together that pro forma. The most common one, for example, is, rent escalation. There's going to be an assumption of how, even after you do all the value add, at some point, once you stabilize the property, you're going to assume there's a certain amount of rent growth year over year. And that could be 2%, could be 3%, could be 5%, could be 1%. And again, you just want to make sure that you understand what that is and make sure you're comfortable with that assumption. And the nice thing with these pro formas is that you can come up with your own assumptions, and you can always stress test it. And even though the sponsor may assume a 3% rent growth, you may want to assume a 1.5% and run the numbers that way and see if that's more comfortable. Same with the bridge loan example I gave you. Just make it that the assumption there is that you're going to be able to refinance in 18 months. And if you think that's fine, that's fine. If not, you want to just analyze that. So just remember, and that's what my job is. My job as a securities attorney is to identify all of the assumptions that the sponsor makes. And they're going to make a ton of assumptions, right? This is all looking into the future. So they're going to make a ton of assumptions, and my job is to make sure all those assumptions are disclosed, and your job is to identify those assumptions and see them, and then make your own determination whether you agree with those assumptions, if you think they're too aggressive or they're too lenient or whatever. So assumptions is a big one. Making sure the PPM exists when it's required. As I mentioned earlier, a PPM is required by law, especially with 506Bs for sure, and it's going to be required no matter what if there are non-accredited investors in the deal. And so I've seen the scenario come up before where they come up with whatever excuse they want to come up with as to why there's not a PPM. But if there's no PPM and there's non-accredited investors, that's going to be a huge red flag. And if they're cutting, it's probably because they're cutting corners somewhere. They don't want to pay a lawyer to do it, or they just don't know any better. And if they're cutting corners there, where else are they cutting corners? And we don't have time to go into a couple anecdotal stories that I've told before, but I've seen it firsthand that when they don't have a PPM, other issues end up happening down the road. So that's another thing you want to look at. The short-term debt we've kind of talked about already, making sure you understand if there's bridge loans or what the length of the loan is, and make sure that that's long enough or comfortable for your assumptions. Multiple exit strategies is something else you want to look at. A good sponsor will have multiple exit strategies. So maybe option number one is a sale, maybe, but what if you can't sell? What if the market goes down and you've got to hold on for it for a little bit longer? Or, you know, sometimes the sponsor wants to do a refinance. Same thing. What's plan B? What if we can't do a refinance? What if we can't sell? What if we can't hold on for it for 10 years? You want to just see multiple exit strategies, which are really just mitigation. Like if our number one strategy doesn't work, here's plan B, here's plan C. And then stress testing this investment. We've kind of talked a little bit about that, but what I like to do, I mean, all the sponsors stress test their deals just on the personal side, so they're comfortable with it. But I think the passive investors should try and stress test, which all that means is just make some assumptions. Like what happens if, you know, there's 0% rent growth, because, you know, we do go into a recession and there's no rent growth. What do the numbers look like there? Or what if, what if my expenses were supposed to go down and they didn't? Or what if my vacancy, that's the other big one. Like, let's say we're assuming this is going to be at 95% occupancy. Well, what if it's at 80? What if it's at 85? What if it's at 90? You can always run your own numbers and stress test this and just kind of see, well, how low can this vacancy go, or how low can the rents be before we can't make our mortgage payment and, you know, things become an issue. So I just think it's really important for passive investors. It's a lot of work, I think, on the front end. The nice thing about passive investing is once you've done the work and make the check, then you can relax and go back and sit on your couch and enjoy the work that the sponsor's doing. But in the meantime, you do have an obligation to really be actively involved on the front end with your due diligence. And part of this due diligence is taking that spreadsheet, that pro forma, and kind of tearing it apart a little bit, make your own more conservative assumptions, or just really look at it in detail. And if you see something you're not comfortable with, then just adjust those numbers into what you think, and then see what comes out. And if the returns are still acceptable, then that's good. Man, I'm already going a little bit over again, I think. So, and then the last thing is the pitfalls, any pitfalls in the structuring. I think again, the first one, I think the main one we've already discussed is just making sure the operating room matches the PPM. I see that a lot. I used to see that a lot, I must say, because I actually don't do it anymore, but I used to review other people's syndication documents. They would hire me to just kind of do a review, which I highly recommend doing too. You know, it's not super cheap, but there are lawyers who can do it for $500 or $1,000, and I think it's money well spent for somebody to take a look at it and give you a professional advice. But it's not uncommon to see operating agreements and PPMs different, and the operating agreement is what dictates. So that's an important thing. The return on investment versus return of invest or capital is a big one. And either one, I don't have a dog in the fight as to which one's right or wrong. You just need to understand which one that you're dealing with. So a return of capital means that if I invest $100,000 into a syndication, and let's say they're giving me a 10% return, so every year that I get $10,000, that $10,000 goes to reduce my $100,000. So year one, I put in $100,000, I got $10,000 return. Now the syndicator only owes me 90. So the next year I get another 10,000. Now they owe me 80 and 70 and 60. And the reason that's important is because at the end of the deal, when you sell 5 years from now, the syndicator does not give you $100,000 back first. They just give you that 50 or 60,000 that they owe you first, and then they start splitting the profits a lot quicker. So it just pushes the risk maybe a little bit on the back end, as opposed to a return on investment, which I think is what most people would consider the typical return, which is I give you 100,000, you gave me 10%, great, I've got a 10% return, and you still owe me my $100,000 until that time comes where you either sell or refinance in the back end. Because not typically, the way it should work is that you as the investor should get all of your money back first before the profits of a sale or a refinance get split. So again, $100,000 goes in, and let's say you sell the property and there's a bunch of cash from the sale. The first thing that has to happen is all the investors get their money back, and then it gets split 80-20, 50-50, whatever the splits are. And so if it's a return of capital, that number just keeps going down. And so the syndicator doesn't have to give you all of the money back on the front end. And then just understanding waterfalls, I think that's another one. My favorite these days, I've been meaning to do an article on this a while, is the preferred returns. Everybody talks about prefs, preferred return, which by the way are not guaranteed returns. Maybe we should have put that in there as well. A preferred return is not a guarantee. It just means you get all the money first until you reach that 8% or whatever the percentage is. Let's say it's an 8% pref. You get 100% of the money first until you reach your 8% return. But if there's not enough money, let's say if there's no money, you're going to get zero. right? And if there's only a little bit of money, you may only get 2, 3, 4%. It's not a guaranteed 8%, but there's so many different ways I've found out lately that you can do a preferred return. And so this kind of goes into understanding the waterfall. So, the traditional one is you get an 8% preferred, and then anything above that you split 80-20, 50-50 or whatever. But there's at least 4 other ways that I've come across now that people are splitting or defining and articulating what a preferred return looks like. So it's just really important that you are very clear on what that is and understand that. And again, if you're not clear, just that's part of the thing. You get the opportunity to pick up the phone and call the sponsor and ask them if it's not clear the way it's drafted. So, and then some people get a little bit crazy. Back in the day, I don't know if you guys are familiar with the real estate guys, but I used to work in-house with them, and we used to do, all of the syndications that the real estate guys would do. And way at the beginning, we just got a little crazy on the waterfalls, and we just got I don't know how many buckets and how many waterfalls we went through, and it just gets really complicated. It was really hard to explain to the investors, and the investors got confused. And so again, the more waterfalls you have, just make sure you understand what really is going on and reading the documents really carefully. That's something I would focus on when they're describing, the preferred returns, and then the next X amount of money is split 80-20, and the next bucket is split 50-50, and you can go infinitely. So just want to be careful about that. But I don't know. I think that's kind of my preliminary thoughts, and I don't know if there's any questions there, but I'd love to open it up to Q&A, because it's one of my favorite things to do is Q&A, and if it was up to me, I would just do nothing but Q&A. So if you've got questions, I'd love to hear them.
All right. Thanks, Mauricio, so much. I know I have a few questions, but I'll go through some of the questions folks have asked me. And please, sorry about this. I'm not able to open the Q&A box again today, so it's punishing me here. So I'm trying to read through the chat box. Let's see. First question: how detailed would the operating agreement be in the steps in terms of situations to get rid of the sponsor?
It's going to be, that's probably one of the most critical things you want to look at. Now, so that the steps there should be very clear on what's the procedures that a passive investor has to go through in order to remove a manager or a sponsor. Typically, there's a notice requirement. Before there's got to be a vote of some sort. So first you've got to call a meeting. So there's a procedure that you have to follow to just even call the meeting and have a notice sent out to everyone, and then there's a voting, and the voting can also be very different for different deals. In all fairness, the ones I do, look, I make it very difficult, to be honest with you, for passive investors to remove managers. I almost limit it to scenarios where they're basically committing fraud or obviously stealing funds, like really bad stuff. That's kind of how I do it. At the end of the day, this is a limited investment, so the idea is you're giving them money and they're going to run the project. But you want to pay attention, because depending on what they're doing may dictate what kind of voting has to happen. So for example, and I'm rambling and I apologize, but for example, most syndicators do what I do, which is they have 2 separate classes, right? Class A and Class B. And so Class A might be 80%, which is the investors, and Class B might be 20%. So does the voting happen, as a company as a whole? Like, do you need to have a majority vote, which is 51%, or 50% plus 1? Is it a super majority vote where you need 2/3 vote or maybe 3/4 vote? So that's the first thing I would look at. And then, is it of the whole company, or is it just of your particular class? Because if it's of the whole company, well, the most you could ever get is 80. Right? Because if every single investor votes to remove the manager, and they only represent 80% of the company, that's the most votes they could have. Class B is typically the manager. They're not going to vote themselves out. So if the voting says 75%, then that's really 75 divided by 80. That's a really high number. So it's critical that all be spelled out in the operating agreement. And it should be. And if it's not, those are definitely questions I would be asking. And if for whatever reason, just big picture legal things too, if for whatever reason something is silent, and by silent I mean it's not in the operating agreement, then what you do is you actually go to the statute. So every single state has an LLC statute, and they almost have like an operating agreement in that statute. And it basically says, look, if it's not in your operating agreement, then this is the operating agreement we're to look at. So if there's something that let's say you're trying to remove the manager. I actually had this come up last year, an operating agreement that I did not draft. We were trying to figure out, actually the sponsors were having a disagreement, and there were multiple sponsors, and it was silent as to, is it a majority vote, unanimous vote? It just wasn't there. So this was a Texas LLC. So we actually ended up going to the Texas limited liability company statute, and that's where it outlined what the procedure would be to remove one of the co-managers because it wasn't in the operating agreement. So that's critical. That's a great question. That's definitely, the voting is something I would look very closely at as a passive investor.
It's a very good point. I learned something new today. Thank you. If a deal being contemplated is a development deal, would it be reasonable to expect to see the terms of the construction loan?
I think the terms of the construction loan would be something that would typically be disclosed in the PPM. Whether the actual loan agreement is disclosed is probably not going to be in the documentation. You also have the right to ask for the things that may not be in there. But I would not expect to see the full loan. I wouldn't see, just like I wouldn't expect to see the mortgage on a commercial loan, I wouldn't expect to see the actual document and the specifics, but I would expect to see the terms in the PPM, probably in the defined terms under construction loan. It would say construction loan is $10,365,000. It's a 7-year, interest, whatever the terms are in that definition. But I honestly would not expect to see that in, as an exhibit to the PPM. But that doesn't mean you can't request it, but it's not something I would expect.
Got it. So I had a question. So you said something about disclosure in the PPM. So you not only disclose about the deal, but also you disclose any background information about the sponsor in the PPM?
Yep, you're required to disclose all material facts. And material facts are any facts that an investor would find important enough or affect their decision to invest in your deal. So sometimes it's a judgment call, but sometimes it's not even close. So for example, if you had anything relating to financial issues, a bankruptcy, or certainly if you've been convicted of something, actually that's actually required as a bad actor, but anything, your background, if you have a felony, for example, that's a really interesting conversation too. Like if you have a felony there, is that something that is material to the investors? I would venture to say most investors say, yeah, I think it's important for me to find out whether this person was a felon or not. So those all get disclosed as part of the disclaimer piece in the PPM. So bankruptcies, anything to do with financials for sure. Felonies, I think, unless it's a really unique scenario. But again, just ask yourself, do you think that would be relevant for an investor if this person would it affect their decision to invest, whether they're a felon or not, or whatever the fact is? And if the answer is yes, then I always err in putting it in there, because the consequences for not putting it in there, you could argue, well, I didn't think that was material. I guarantee you the investor is going to come back later on if they've lost money and say, there's no way I would have invested in your deal if I had known this, that, or the other. So we always err in the side of putting it in there. But sometimes that's a discussion with the client, and as long as they understand what the risks are. But yes, everything having to do with anything that's material that the investor should know or would affect their decision to invest in your deal should be in there.
So let's say the sponsor had a deal go south and actually lost a property. Would that be something like, it wasn't a personal bankruptcy, but it was a bankruptcy of the LLC, or they lost the property? Would that be in there?
I don't know. You're kind of putting me on the spot. I'd have to look at the other requirements. I think every single syndicator, well, maybe not these days, but I mean, it's certainly not the end of the world that people have lost money. That happens. I think if you do this business long enough, you are going to lose money. But that might be something you want to put in there. It's certainly something that I would consider as an investor.
Sure. So one more question here. How do you stress test? I think you answered this. How do you stress test a plan? I feel like you answered that.
Yeah, you can answer that even better. I mean, I think, basically what you want to do is the two easiest variables are occupancy and rents. And so how low can your occupancy and rents go before you don't have enough money to pay the rent, or maybe more importantly, that your debt coverage ratio goes below whatever the bank's requiring. So if the bank's requiring 1.25, meaning they're expecting you to have at least 25% more income than that is owed, and you drop below that, then that's probably what you want to stress test. How low can your rents be and occupancy be and still stay within that 1.25 debt coverage ratio or whatever it is that the bank's requiring.
And if that stress test is not mentioned in the document, it's something you should definitely ask a sponsor for, because most sponsors would have stress tested, at least should have stress tested a deal before they actually get into it.
Yeah, you can ask. That's a great question to ask, actually. Even I don't know if you share that spreadsheet, because the spreadsheet's going to get a little messy, but that's a great question to ask a sponsor is, have you stress tested this? And, what are you, at what point, what are the results of that stress test? How low can our occupancy go before we're in trouble? And, if it's 70%, then and you feel comfortable because we're at 90, that might be one thing. But yeah, that's a great question to ask the sponsor.
Yep. All right. Christine asks, one does not have to be an accredited investor to participate. Yes, you don't have to be. If it's a 506B, I think, yeah, we don't need only accredited, but if it's a 506C, you do need to have only accredited, right?
That's correct. It depends. It'll depend on what exemption the sponsor is relying on. Most will rely on a 506B or a 506C. Most will really do a 506B, and under that B, you can accept up to 35 non-accredited investors as long as they're sophisticated. But yeah, if it's a 506C where they're advertising, then you are prohibited from accepting accredited investors. So it just depends on the exemption.
Okay, let's see. What are the 4 items breakdown of the pref? I don't understand this question.
Yeah, I'll give you 2. I don't want to get too, so I'll give you 2 examples. So I'll give you 2 different ways a pref can be done, and just understand there's 4. Well, I'll do it even simpler. So a preferred return, let's say you're getting an 8% preferred return. What if you're short of the preferred return? So let's say you're promising me 8% pref, but there wasn't much money generated this year, and so I only got a 5% return. So you were 3% short. One way to do it is that simply rolls over to the next year, right? So let's say you were supposed to give me, I'm going to go really round numbers. You were supposed to give me $8,000 this year. You only gave me $5,000, so I only got a 5% pref. So you owe me $3,000. That's going to roll over to the next year. So you first have to give me the $3,000 that you didn't give me last year plus my 8% that year. And you just keep rolling it over. That's one way to do it. The other way to do it is it doesn't roll over. It's an 8% pref, but if you're short, tough. You're not going to get your 8% this year, and we start from scratch next year and the following year. Another way to do it is if you're short, it gets carried over, but not to the next year. It'll get carried forward until you sell. So you just kind of get credit for it, and then 5 years later, when you sell, then that's when you get the pref. So even that right there, you've got 3 differentiations. But then the other one that I've seen a lot lately is it's a floor. So let's say it's a 80-20, an 8% pref 80-20. Instead of doing 8% first, and then anything above that is 80-20, you just start with 80-20. And if that 80% is below the 8% pref, then the manager starts throwing money over the fence, so to speak, from their share until you get to that 8%. And if you run the numbers, that's slightly a different result than the traditional 8%. And then even in that example, same thing, if you're short, even if you're throwing money over the fence and you're still short, what happens? Are you rolling it over? Are you not rolling it over? And if you roll it over, is it till the next year, or is it till there's a refinance or a sale, multiple years down the road? So there's multiple ways of doing a preferred return. My point was simply make sure you're reading that paragraph carefully and it's clear to you what exactly they're doing when they tell you they're giving you an X% return, preferred return. That
makes sense. Okay. Rita asks, how much should I expect to pay a lawyer to assist in a syndication? Rita, I assume that you mean to drop the syndication documents as an active, or as a passive to review your syndication?
As a passive to review, when I was doing it back in the day, I was charging just kind of a flat fee of $1,000, and that's because what I was doing is I would meet with the client over the phone and find out what their understanding of the deal was. Then based on that, I would then review the documents to, number one, see if there's any red flags in the documents, but then more importantly, again, is to compare the version that the client gave me and the actual docs. And if there was discrepancies, I would point that out. So giving my pref, for example, they may say, oh, my understanding is there's an 8% pref, And then I would read the docs, and there was no 8% prep. So that's something I would point out to. And of course, then there's the follow-up call after I review the docs. So I don't know, about 1,000. I would say somewhere between 500 to 1,000 to $1,500, depending on the lawyer and depending on how long, whether they're doing it hourly. But it shouldn't be too much. And I think if you're putting in $100,000, it's definitely worth that price. I think because that's a lot of money that you're putting in. And what's the saying? An ounce of prevention is worth whatever.
So as an active, she says both. So as an active investor or syndicator, what would be expecting to pay for setting up, creating all the syndication documents? I think we typically paid around 15 to 20,000.
Yeah, we do a flat. Everybody has it differently. We do a flat fee. I mean, I'm not afraid to tell you, we do a 15,000 flat fee.
Mm-hmm.
But it's not just it's kind of actually one of my pet peeves. It's not just drafting the documents, because that's definitely part of it. But I would actually put that at about 20 or 30% of what we do. It's really making sure that you're compliant with the raise, with federal and state securities laws. There's so many other things out there that you've got to look out for, just from the most common ones. Are you paying people to raise money? You have a lot of co-sponsors? Do you have broker-dealer issues that you might be crossing the line on? Are you advertising on social media? Are you doing, are you an investment advisor? Do you need to register as an investment advisor? There's just all these little check boxes that you're going through in your mind. And again, most of the time, maybe you don't even address those, but it is going through all that compliance and making sure you're complying with the rules, not just drafting docs. And of course, spending a lot of time with the client to make sure that we understand the deal, so we know what to put in the PPM. You can get a PPM off the internet. It's worthless. It's all about what information the attorney is getting from the client, and then putting that information, asking the questions. We spend a lot of time with the clients so we can draw that information out of them, because they don't know what they're supposed to be, disclosing. So we pull that information from the client, and then we put that in the PPM and all the disclosure documents. So it's a lot more than the doc, but that's kind of it.
Hey, Rita.
Thank you for unmuting me. What I'm trying to do is get women in Australia to invest in US properties. So I would want to set up an LLC and have all the documentation done. So we pay our taxes in the US and everything through the US, because Australia has a treaty with the US. So all I want to do is get women to invest and go and get a syndication together. Go through a syndication in the US. So that's really what I want to do, but I need some documents done in the US.
Are all of your investors in Australia?
Yes.
And the only thing in the US is the project?
Exactly.
There's an exemption specific for that. I actually did a video on this by the way, if we're not friends on Facebook, please friend me and just let me know that you're on this Q&A, and I'll get you in there. But I did a video on this on international investors. If you don't market in the US and you don't sell in the US, and what I'm hearing from you is that you are selling and marketing only in Australia and it sounds like you live in Australia too, right?
Yes, I used to live in the US.
So the SEC, the US, they don't care about Australian investors. They don't care about Canadian. They care about US investors. And so there's a specific exemption called Regulation S as in Sam, a Reg S, which is different from what we're used to, which is Reg D as in David. Reg S is specifically designed for your situation, which is I'm not advertising, I'm not selling, I'm not doing anything in the US from a capital raising standpoint. It's all happening in Australia, and you're entitled to rely, just based on what you're telling me, rely on that exemption. Now, you do have to be careful to make sure that you're complying. At that point, you're obviously in Australia, so I don't know what the securities laws are in Australia, and you want to make sure you're complying with them and whatever their rules are. But from the US perspective, you're going to be able to rely on Reg S, and you're right, you would still create a US LLC to hold the property, but you wouldn't have to worry about a PP, at least at the US side, a PPM, all that other stuff.
Okay, that's great. Rita, I think I muted you, so you can take this offline with Mauricio. I do want to get through the other questions.
By the way, and look, I really appreciate there's everyone's still online, which I'm still, honored to do that. So, and I know you're going to give my contact. If you've got a follow-up question or something either we don't get to or you, think of it afterwards, please just feel free to email it to me. Just let me know that you were on this thing, and we'll get an answer out to you.
Yeah. And I'm happy to share Mauricio's email. When I post the YouTube video, I'll probably throw the email in at the end or at the beginning, so you guys have his email. Okay, let's get through a couple more questions. Mauricio has a hard stop at 8:30 Central, so let's see here. On the subject of clearly differentiating ROI and ROC returns, is there any particular language to look out for in the operating agreement? When modeling it out, it shows up in the waterfall pro forma, but certainly that would not be enough.
Yeah, so it's going to show, well, it's going to show up, so a lot of times shows up mistakenly, but if it's a return of capital, it should not say cash on cash return. I think that's misleading because cash on cash return really talks about a return. So where it's going to show up is it could show up in the pro forma because a lot of pro formas have sort of the equity. You can actually reverse engineer it actually, because when you look at the ROI, it's not a lot of time, but the returns that the sponsor gives you, let's say year one, you're going to make 6.3%, year two, you're going to make 7.4%. That's all based on your capital, your what I call the unrecovered capital account. So if it's not specifically stated what your capital account is at the end of every year, you can actually figure it out based on the NOI and the percentage, the ROI percentage. You can then figure out, how much money is there. But honestly, you shouldn't have to. You should just ask. You should just ask the sponsor and just get clarity on that. And then and maybe this is what you're asking in the operating agreement. In my operating agreements I have a special exhibit that says all the preferred allocations, so that it would definitely be there. But also in the tax section would be another section that it would be articulated that this is a return of capital as a return on investment. And let me just take one more. I try and make mine super clear. So I actually have a definition in the operating agreement that I call unrecovered capital contribution. So that definition is where I spell out very clearly whether this is a return of capital or return on investment. That's how I do it. I don't know how everybody else does it, but look for a definition of unrecovered capital contribution, which will be your initial capital contribution minus whatever they're giving back to you. That's your unrecovered capital contribution. And that's what we base everything off. So a preferred return typically is based on that number, which is why that number, that's another example in the preferred return. That's why that number goes down every year, because now it's, instead of being 8% on 100 grand, it's 8% on 90, 8% on 70, 80, 70, 60. So that's where I have it in my docs is the definition of unrecovered capital contributions. But there should be something similar to that in the operating agreement.
Okay. So the next question is, I think this is a weird one. Is it reasonable to ask who are the other investors and their contact info? Typically, I don't think any sponsor would want to share that, nor the investors would want to share that. Mauricio, what's your take on that?
I do have a take on this, and it's not popular with my clients sometimes. I just haven't figured out another way to do it. So you have to put the investors in the operating agreement. There should be an exhibit that lists all of the investors' name and their capital contribution or more importantly, their percentage ownership. With LLCs, we don't have stock certificates. The way you show your ownership in an LLC is through the operating agreement. So when you have a fully executed operating agreement, I can show the bank or whoever that look at Exhibit A that lists all the investors. Here I am, Mauricio, I own 2.7% of this company. That's how it shows. But more importantly, in the operating agreement, there's all of these notice provisions. So if you want to remove the manager or you want to call a vote, there's a procedure, we talked about it earlier, where you have to give notice to all of the other investors. So if you don't have that information somewhere in the operating agreement, how are you going to give proper notice pursuant to the operating agreement? Now, we were getting a little bit creative. I've looked into it a little bit. It's like, you could give the notice to the manager, but what if you're trying to remove the manager? That's not a very, how do you know they're going to give the notices to all the investors? Maybe you get a third-party escrow. I mean, it gets really complicated. So my answer is yes. Exhibit A, or one of the exhibits to the operating agreement, should list all the investors, their address, because you got to mail them. I wouldn't put an email, because email, it just makes it really easy for people to put together a Facebook group or a Google group or whatever, and then all gang up against you. But name, address, and what percentage ownership everybody has, so that we can figure out what everybody's voting rights are, and we can follow the procedures of voting.
So do a lot of syndicators do this in your syndications?
Yeah, they all
ones
do.
you
I've had a couple. I have had a couple of that brought that point up, which is I'd rather. Well, first of all, the main objection comes from the passive investors, and they're like, well,
Right.
it's my privacy, right?
Right,
My
right.
response to that is you can handle that on your own. If you really are worried about privacy, then set up an LLC. Don't put your personal name on there. Set up an LLC. I mean, there's ways that you can be completely private. Or if you don't put your home address on there, then go get a PO box or get another. There's ways for you to get around if the privacy issue. I think the bigger issue, or the time it's come up that I'm trying to solve, is when my clients, the sponsors, don't want to share and have all the other investors know who the other investors are, just because there's some proprietary, they just, especially if there's another sponsor in there, do they want to have access to their investors? But I just don't know how you do it when the operating agreement clearly allows you to provide notices to all the other investors. Well, how are you going to provide that notice? So if anybody finds out, I'm not saying I have all the answers. So if anybody's got a suggestion on how other people are doing it, I'd love to hear it. But that's my concern is how do you the operating agreement?
So quick question. What if you set up a group email for all the investors who are in that group, and it could just be an email alias to contact them all, and that way they have their privacy, but yet still you can potentially, one investor could reach all the others. I'm just tossing it out there.
Yeah, that's a great. I haven't thought of that. Let me digest that. I hadn't thought of that. Maybe there's something there.
Okay, so the next question is, do lack of rights to inspect the books or remove the manager for cause be a cause for concern in a PPM?
Typically, that's in the operating agreement, not necessarily the PPM. But yeah, there should be a procedure to inspect the books. My operating agreement does have the procedures. There's nothing wrong with you charging for that. Just because somebody asks you to, that doesn't mean you've got to do all the work. So you could limit it to inspection. So if the investor wants to travel to my office and inspect the books, they can do that at their expense. If they need to make copies, like at their expense. But a lot of states, and again, it goes back to the LLC statute, a lot of states have that in their statutes where it's required that the certain documents that the sponsor has to keep. And one of them, for example, is a list of all the investors and their addresses. And that's something that the investors can request. So again, it depends on what state you're in. I'm specifically thinking of Wyoming, but yeah, should it be cause for concern? Sure. I think it should be. Like, why? I always ask why. Like, why won't you let me look at the books or the tax returns? I mean, the tax returns are usually one of those documents. The operating agreement, the tax returns. Certainly, the K-1s will be either redacted or maybe not even in there. But yeah, I mean, my operating agreements all have a right upon reasonable notice too. I mean, some people, it doesn't have to be immediately or within 24 hours, but upon reasonable notice, there's no reason why members shouldn't be able to inspect the books and at their expense. And maybe they got to fly in and look at it in person. But certainly, I think I would want to, as an investor, have that right to look at the books. Right.
Agreed. In the interest of time, I want to be mindful of your hard stop, Mauricio. It's 8:33 Central here. So yeah. I think we have a few more questions. I'm going to share your email with folks so they can ask you directly if some questions haven't been answered here today. I'm not getting through all of them. So yeah, so we'll let you go, and thank you so much for being on. I really enjoyed having you, and thank you for sharing your thoughts with our viewers today, and I hope everyone it was useful to you and understanding the documents, and so you can do this better as a passive investor. There are a few more questions, so I will share Mauricio's email with the recording today. Actually, I'll be sharing it tomorrow. So you should have, you can ask him the question directly. Thank you so much, everyone, for joining, and have a great night. Thank you, Mauricio.
Thank you. Appreciate you guys. Thank you.